Can the government of India taps the phones of suspects to gather evidence before a crime is committed? Last week in two separate cases, the Madras and Delhi High Court have gave a varying answer to this question. What is a law on phone tapping in India and how have high courts interpreted it? Let's see this in today's video. The government's power to intercept communication is laid down and circumscribed by three pieces of legislation. First, the Indian Telegraph Act of 1885, used for tapping voice calls. Second, Indian Post Office Act of 1898, allows for the interception of communication through post. And last, the Information Technology Act of 2000 governs the interception of WhatsApp messages, emails, etc. The 140-year-old Telegraph Act was originally meant for intercepting telegrams, but over the years, it has expanded to include telephonic conversation. Section 5(2) of this Act states that both state and central government can, on the occurrence of any public emergency or in the interest of the public safety, authorize interception. Given that the right to free speech and right to privacy are basic fundamental rights, any encroachment on these rights through surveillance is only permissible on narrow constitutional grounds. But what are these constitutional grounds? These grounds include the interest of sovereignty and integrity of India, the security of the state, friendly relations with the foreign state, public order, or preventing incitement to the commission of an offence, are enumerated as reasonable restrictions under Article 19(2) of the Constitution. Section 5(2) of the Act also mentions these grounds for authorizing interception. For actions to be deemed a threat to public emergency or in the interest of public safety and allow for interception, they have to necessarily fall into one of the reasonable restrictions. Both the Madras and Delhi High Court cases involved preventing the incitement to the commission of an offence, which is one of the valid grounds for authorizing phone tapping. Both courts separately examined the nature of economic offences to determine if they could be deemed as public emergency or public safety. While the Delhi High Court upheld the interception order, on the other hand, Madras High Court quashed it. On June 26, the Delhi High Court rejected the plea of an accused who challenged trial court's order accepting the evidence gathered by CBI through phone tapping. The case related to the accused allegedly seeking to secure a subcontract for the redevelopment of the ITPO complex into an integrated exhibition convention center through corrupt means. In 2017, the Ministry of Home Affairs had authorized interception of his phone on the suspicion that he was attempting to bribe a public official. Justice Amit Mahajan stated in his order that given the contract was for rupees 2,149.93 crore, the economic scale of the offence, in the opinion of this court, satisfies the threshold of public safety. The High Court in its statement said that the threat posed by corruption cannot be understated. Corruption has a pervasive impact on nation's economy, and the same can impact anything from infrastructural development to resource allocation. Corruption by a public servant has far-reaching consequences, as it serves to not only erode public trust and cast aspersions on the integrity of public institutions, but also renders the public at large susceptible and vulnerable by threatening the economic safety of the country. The Madras High Court on July 2 quashed the interception order issued by Ministry of Home Affairs in 2011 for intercepting the phone of an accused in a bribery case. The accused was allegedly attempting to pay a bribe of rupees 50 lakh to an income tax officer, to a senior income tax officer, to help the accused hide undisclosed taxable income. Justice Anant Venkatesh in his order stated that a public emergency must be construed narrowly. In the petitioner's case, the MHA's objective to deal with tax evasion would not qualify as a public emergency under Section 5(2) of the Act, the court said. Additionally, the court said that phone tap was unlawful since it did not comply with the procedure standards set by Supreme Court in a 1977 ruling. And once a phone tap is declared unlawful, any information gathered through phone tap cannot be treated as evidence in a court of law. In its landmark 1997 ruling in People's Union of Civil Liberty versus Union of India, The Supreme Court examined the constitutional validity of Section 5(2) of the Telegraph Act. While it upheld the law, the court laid down procedural safeguards for its application. The Supreme Court said that the order for phone tapping can be issued only by the Home Secretary of that state and central government, and that this power cannot be delegated to the officers below the rank of Joint Secretary. The authorizing authority must also consider whether the information could reasonably be acquired by other means. Within 2 months of ordering a phone tap, a committee comprising the Cabinet Secretary, the Law Secretary, and the Telecom Secretary shall review the order. At the state level, the committee shall comprise the Chief Secretary, Law Secretary, and another member other than the Home Secretary. So at last, both the Delhi High Court and Madras High Court have made one thing very clear, that phone tapping is not a tool for routine surveillance. It is a clear or a serious intrusion into an individual's right to privacy. And it can only be used in the rarest of circumstances, like during public emergency or when public safety is under threat. Because privacy matters, law matters, and the power to intercept phones must come with strict checks and not unchecked authority. The courts have spoken that phone tapping is not above the Constitution. So thanks for watching this video.